Nigerian legal community was jolted on Tuesday, February 13th by the news of an alleged signing of the Enhanced Trade Investment Partnership ETIP agreement between the governments of Nigeria and the United Kingdom. It was reported that this agreement seeks to enable cooperation between the two countries in areas such as financial and legal services that will allow lawyers from the UK to practice in Nigeria. The news set legal chat groups on fire, with many condemning and others applauding the move. The Nigerian Bar Association, in its reaction, described the move as totally unacceptable and vowed to challenge the legality of the agreement all the way to the Supreme Court if necessary. There has since been an update from the Minister for Investment, Trade and Industries that there was no such legal agreement. But this has not stopped the flurry of questions about the implications of such a move for lawyers and Nigerians. And this is the starting point of my conversation with a cross-border solicitor, a former president of the Commonwealth Lawyers Association, senior advocate of Nigeria, Boma Alabi, OON.
Well, I think it's a great development. The more cooperation there is between the two countries, the better. Nigeria is in a dire economic situation at the moment, and anything we can do to enhance trade and economic activity has to be a good thing. However, the legal aspect of it was never part of the agreement. And the minister came out to say so on her tweet, that this was not part of the agreement at all, and they made an error in including it. I suspect because Helen Grant MP, the Prime Minister's envoy, trade envoy to Nigeria, former lawyer, 23 years as a lawyer, and now part of the group, the working group that's looking at how we can possibly open up the legal space. That may have been part of it. I have no idea what went on behind the scenes. But in my view, it should be on the table. We should be having that conversation, and we should not shy away from it.
In response to the alleged agreement, the president of the NBA says that the knowledge and skill gap between Nigerian lawyers and those in the UK is significant. According to him, legal practitioners in Nigeria cannot compete favorably with their UK counterparts. Do you agree with this assessment?
Our president, Y.C. Mikel, is the president of the bar, and of course also a very good friend of mine. And so I have enormous respect for him. But on this occasion, I respectfully beg to differ, because I used to be president of the Commonwealth Lawyers, as you know, so that's 54 countries that practice this same law that we do. And most of those countries, because of the similarities between the laws that we practice, have minimum entry barriers to lawyers from other Commonwealth countries. As a matter of fact, if you look at our LPA, it says that you will admit lawyers who have similar law to Nigeria. So it recognizes the fact that there are other countries that practice similar law to us. So it's more practical to begin to look at regulating foreign lawyers coming to practice here, as opposed to trying to keep them out. We have not kept them out. We've not succeeded. And it's only going to get worse. So it's to recognize that reality and regulate how they practice law here. It actually has, to my mind, a very bright side to it. We've seen in jurisdictions where they've opened up, they've created employment for the local lawyers. They're not going to fly solicitors and barristers to Nigeria to come and work for them in Nigeria. Your fees here will not sustain that. But they are going to be working with local lawyers, partnering with them, and developing some of those skills that the president says we currently do not have. But in terms of our lawyers and their ability to compete, I can tell you, lawyers have left my office in Lagos and Japat. Yes, UK, Canada, United States, working and practicing law and competing with their contemporaries and in all of those jurisdictions very, very favorably.
I hear what you say about JAPA and the need to start looking at regulations, but would you say that Nigerian lawyers have the same opportunities potentially open up to them abroad?
As a matter of fact, yes. What the United Kingdom is looking for is reciprocity, because already they've opened up their market to us. I practiced law in England for many, many years, and I practiced because I was a Nigerian qualified lawyer. I did not have to go to through the whole rigor of going to the law school again and all of that. All I had to do was take a number of exams. I think there were 3 or 4 exams, and that was it. So my Nigerian qualification was recognized, and I was able to practice in the United Kingdom, practicing UK law. As a matter of fact, if you do not wish to practice UK law, you don't need any qualifying exams.
Anymore.
You never did. You can literally just set up shop and say, I'm here practicing as a Nigerian lawyer.
Another objection which the NBA raised through its president is that the state of the Nigerian economy presently does not allow for such agreement. He says government is saddled with the responsibility of creating opportunities for more than 140,000 lawyers currently practicing across the country, and also over 4,000 new wigs that are called to the bar yearly. What's your response to this argument?
I would say the challenge is not that we have too many lawyers. The challenge is that we have not communicated our value to the people who ought to be using our services. If they understood the value we brought to the table, more of them would be using lawyers and thereby creating more work for our new wigs. Most of the society tend to think of lawyers purely when it relates to litigation. They have no idea how important it is that we're part of their property transaction, for instance. People are buying property on water channels, they're buying properties that haven't got proper planning permission, and then they're having things knocked down after they finish building. That's because they haven't got a lawyer involved in the transaction. The Nigerian Bar Association has a role to play in educating the public about the use, the value we bring to the table. We're not only in court, we want to be with you before we go to court and help you to manage your risks. That's a key part of what we do that doesn't get communicated very well in this jurisdiction.
And that part about the economy not being conducive enough for the legal space to be open up, you agree with that?
Well, you recall that the minister said that legal was not part of it, so that was an error in the first place. That being an error, no wonder the NBA was not involved, because the legal aspect was not on the table. And with the Attorney General, we have the Attorney General of the Federation currently. He's a proper barman. He would be in that room and he would insist that absolutely give the proper advice that the NBA has to be in the room.
Opening up the legal sector in Nigeria has been a contentious move for many years for so many lawyers. Why do you think that some Nigerian lawyers are resisting this move?
I think we haven't understood the position properly, and that is why there's so much resistance. The reality, and I repeat that again, it is the fact. I do not have to be in Nigeria to practice. Particularly post-COVID, we are having virtual hearings. We are having virtual meetings. We can be anywhere. And we have to accept the reality that these options are available, and Nigerians and Nigerian institutions and Nigerian companies and even government agencies are taking full advantage of it. So, that's the reality. And if that's the reality, then let's deal with the reality and regulate around it so that we ensure that it is properly done. So, for instance, you could say, well, you can come here and practice your law, but you can't practice Nigerian law because you don't know enough about it. That's step one. That would mean that, okay, I can set up to practice Chinese law. or Korean law. And why not? Step one. Step two would be, you want to practice Nigerian law, there are certain areas that there are commonalities between your jurisdiction and ours. That would be common law practitioners, obviously not Chinese or civil law practitioners. You can take these number of exams, go to the Nigerian law school, same as everybody else, and if you need some additional exams, like the students who come back from studying abroad, bar part 1, bar part 2, then you sit the exams, pass the exams, and then you'll be called to the bar. That obviously requires a change in Legal Practitioners Act to remove that citizenship requirement. Because until that is done, you know what an uphill task it is to become a Nigerian citizen in the first place. We complain about other countries, but the Nigerian passport is one of the most difficult to get if you're not entitled to it by birth. We do not have to reinvent the wheel. We can look at what is going on in other jurisdictions, see what works for us, and import that, and then make it uniquely ours. India, for instance, India was similar to Nigeria up until about a year ago, when they opened up the legal services space. But they've opened it up only partially. So foreign lawyers cannot come to India and practice all the different areas of law. Rather than flying in and out with their briefcase, which is one aspect, they can now set up to practice their own law. They can work with Indian colleagues to practice Indian law. So I'm the one who's qualified in Nigerian law, for instance. You're setting up chambers or law firm. I will be the one in charge. My Nigerian qualified colleagues will be working with me, and you effectively will simply be the rent holder. I don't see what's wrong with that. That's not taking work away from Nigerian lawyers. That's giving us additional opportunities to work. But what I'm vehemently against is, as the law stands, then you have to respect it. You can't have companies bringing in in-house counsel to work in Nigeria because they're employed, for instance, whilst they're not Nigerian qualified. It is what it is. You have to respect it. You cannot bring in your general counsel to work in this jurisdiction. You have to employ a Nigerian lawyer. And respect the position.
With all of the back and forth between the government and the NBA, the average Nigerian just thinks that this is a lawyer's problem. But ultimately, what would you say is the benefits of this agreement when it's eventually on the table? What is the benefit to Nigerians?
Competition is good. That's the benefit. Competition will raise standards. And I keep saying it, I'm as good as the worst lawyer that the public deals with. So if I have a very high standard and you don't, the disadvantage that to you is that you may fall into the hands of that lawyer who is not as competent or does not maintain that high standard. That is going to take away confidence in our profession, and that is a lot of what we're seeing in our society. So I would welcome competition because it will help us to, raise our standards and benchmark for excellence. We tend to think of ourselves as Nigerian lawyers. I don't think of myself as a Nigerian lawyer. I see myself as a lawyer full stop, because my competition is global. My clients are mostly not here. And you have to meet the same standard as your colleague in London, as your colleague in New York, as your colleague in Ontario, or wherever else they may be in the world. And that's how we have to begin to think. So I would say bring it on, but structured, regulated, and ensuring that you're only permitted to practice in the area that you have competence. If you haven't got the competence, go to law school and get the competence. And clearly for Nigerian law, you will need additional training. So again, that's additional income for the law school and so on. Although we have such a backlog of law graduates currently who are waiting to go to law school, you join the queue if it gets to that point. But I really don't think we have to open up to that extent. I think we should regulate the briefcase in, briefcase out situation. We should regulate the situation where you can practice the law that you have expertise in here. And that way we know exactly what you're doing. And we're able to measure what you're doing. We're able to get some income from what you're doing, rather than pretending it's not happening.
Thanks for staying tuned. The Nigerian Bar Association has continued to reiterate its non-acceptance of any agreement on legal services between the UK and Nigeria. The president of the bar, Yakubu Mekiao, told journalists at a press conference in Abuja that the association will continue to oppose any agreement that will compromise the country's legal space.
Irrespective of the minister's attempt at clarifying this statement, we want to state clearly that the objection of the NBA to the said agreement persists. The NBA has been involved in a number of meetings where the idea of allowing UK licensed lawyers in our legal space was discussed. We are therefore very clear about the intention of this agreement. We understand clearly what these agreements are meant to serve. In all these meetings, we unequivocally said that the state of the Nigerian economy presently does not allow for such agreement. It is very sad that while the UK government is creating opportunities for its lawyers outside the United Kingdom, the government of Nigeria, by its action or omission, seeks to shrink the legal space for an already burdened legal practice. What efforts has the government of Nigeria made to ensure that Nigerian lawyers have access to the UK legal environment? What is even more tragic is that the agreement was entered into without engaging the NBA on the text of the agreement. This is a clear indication of the limited recognition the government of Nigeria attaches to its professional bodies. We are certain that the UK government will not treat its Law Society and Bar Council in such despicable manner. For avoidance of doubt, let me say clearly that the NBA rejects the agreement insofar as it relates to legal services. We fully intend to seek judicial review of the agreements, including up to the Supreme Court, if necessary.
The NBA president also used the opportunity of the press briefing to urge President Tinubu to declare a state of emergency in the country because of the security challenges.
The entire country is under siege by terrorists, bandits, and criminal gangs. It is no longer easily determinable, if not impossible, which square kilometer of the Nigerian territory is under the authority or control of the federal government of Nigeria. A situation where criminality dots all over the space known as the Nigerian territory in a manner that diminishes the presence of law enforcement agencies directly challenges the sovereignty of Nigeria. Some Nigerians have lost, and many more are fast losing confidence in the ability of the federal government to deal with the security situation in Nigeria. At this time, when public confidence in the sincerity of government in dealing with insecurity is at its lowest ebb, something radical must be done as a matter of emergency.
And just before we go, a quick recap of some of the top legal stories. in the news.
We begin with the report that the Supreme Court has dismissed the appeal filed by the federal government against the reversal of the conviction of former Niger Delta Minister Godsdale Rubebe on allegations of breach of code of conduct for public officers. In its judgment, a 5-member panel of the Apex Court held that the appeal by the federal government was incompetent. In the lead judgment, the court held that the appellant failed to obtain the prior leave of the court before filing the appeal, which was based on grounds of mixed law and facts. The court held that since the prior leave of court was not obtained as required, the appeal was incompetent and proceeded to dismiss it. Staying in Abuja, the former secretary to the government of the Federation, Mr. Boss Mustapha, has testified before the Federal Capital Territory High Court in the trial of the former governor of the Central Bank, Mr. Godwin Emefiele. Mr. Emefiele was accused of impersonating the former SGF to obtain the sum of $6.2 million. Boss Mustapha, who testified as the second prosecution witness, told the court that the signature, which purportedly emanated from former President Muhammadu Buhari for the payment of foreign election observers, was fake. Mustapha also clarified that he knew nothing about the transaction until he left office. The trial judge, Justice Hamza Muazu, subsequently adjourned the case to the 7th, 11th, and 25th of March for continuation of trial. At the Federal High Court, Abuja, the federal government has discontinued the trial of the presidential candidate of the African Action Congress, Omoyele Sowore, and his co-defendant, Olawale Bakare. The decision to discontinue the trial was communicated to the court via a notice of discontinuance filed by the Attorney General of the Federation and Minister of Justice, Lateef Fagbemi. Mr. Sowore and Bakare were arraigned before the court in 2019 following a protest rally he staged in Abuja tagged Revolution Now. Before the notice of discontinuance, Justice Emeka Nwite had threatened to strike out the treason charge filed against Sowore if the Nigerian government was not ready to diligently prosecute the case 5 years after it was initially filed. Another federal high court sitting in Abuja has ordered the Attorney General of the Federation and Minister of Justice to reopen investigation and prosecution of those who murdered the founder of Newswatch magazine, Delegiwa, in 1986. Justice Enyang Ekwo held that the AGF was under obligation to prosecute and penalize killers of media practitioners in the country. The court granted the order at the instance of the Incorporated Trustees of Media Rights Agenda, MRA, who sued the AGF before the court for the enforcement of fundamental rights of media practitioners to safety as guaranteed by the 1999 Constitution and African Charter on Human Rights. Apart from Delegiwa, who was murdered on October 19, 1986 in his Lagos office through a letter bomb, the court also ordered that the killings of other journalists in the discharge of their lawful duties must be investigated and perpetrators brought to book in line with the provisions of the law. Justice Ekwo ordered the federal government to ensure adequate protection and safety of lives of journalists as enshrined in Sections 33, 39 of the Constitution and Articles 4 and 9 of the African Charter on Human and People's Rights. And we round off in Lagos, where the Federal High Court has granted an order of substituted service on all states in the Federation in the suit filed by Senior Advocate of Nigeria, Femi Falana, seeking to compel the federal government, the 36 states, and Abuja to provide free and compulsory education up to junior secondary school level. At the proceedings before Justice Daniel Osaigo, Falana's lawyer, Taiwo Olawanle, moved an ex parte application for substituted service of the originating motion to be served on the states through their liaison houses in Lagos. Justice Osiago granted Olawanle's application. He ordered that all the states of the Federation be served the originating processes and other subsequent processes through their liaison houses in Lagos. The court then adjourned till May the 20th, 2024 for hearing. Falana and an early childhood education specialist, Hawa Mustafa, filed the suit for themselves and on behalf of the Alliance on Surviving COVID-19 and Beyond. The duo sued the federal government through the Attorney General of the Federation, the Minister of Education, the Universal Basic Education Commission, UBEC, over the failure to access 68 billion naira Universal Basic Education Commission funds to provide free basic education for every Nigerian child of school age. The Attorneys General of the 36 states of the Federation and Minister of the Federal Capital Territory Abuja were also listed as respondents in the suit.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I am Shola Shieli. Thank you for watching and see you next week.